I'm going to take a look at the recent High Court case involving a number of publicans who brought a High Court case against FBD Insurance Company for losses arising from being closed essentially due to the COVID-19 pandemic. And the publicans in question wished to bring a claim against or off their insurance policy on the basis that they were forced to close because of a pandemic. The insurance company wouldn't pay out and the High Court had to decide. There is 5 lessons that I see from the High Court decision. The first one is that the FBD argued that the policy provided for a 25-mile limit. In other words, that the closure had to arise from the pandemic within 25 miles of the pub. However, and if they couldn't prove this, well then they couldn't claim off the policy. The High Court held that even though they couldn't prove that all of the closures of the pubs arose from cases within the 25-mile radius of the pub, it was enough that some cases occurred within 25 miles, and yes, some cases did occur outside the 25 miles. Nevertheless, they were entitled to be paid out and to claim on the policy and succeed. The second lesson to be taken from the case is that the COVID pandemic, according to FBD, they argued that this was not an event but a series of events or happenings, and the insurance policy only covered an event. The High Court did not accept this argument either. They decided that the event that's covered in the policy could be a state of affairs such as a pandemic. Thirdly, there's a question of, there's a thing called a but-for test. FBD were arguing that the publicans couldn't be paid out because if you applied the but-for test, they couldn't prove that the closure arose because of the pandemic per se. In other words, in order to pass the but-for test, they must prove that the only reason for the closure was the pandemic. And the FBD were arguing that other issues brought about the closure, for example, government policy, government decisions and so on. The High Court decided that applying an overly technical but-for test would basically lead to a manifest, or could lead to a manifest injustice, in which case the High Court decided that if there was other causes as well of the closure, then that was fine. That wasn't going to disbar or disentitle the publicans from a successful claim. So the but-for test was modified to a certain extent. The fourth thing that we can learn from this High Court case is that the publicans cannot maintain a claim for losses arising from the continuing effects of the pandemic when they are permitted to reopen, unless they can show that the losses arose as a result or a consequence of the imposed closure. So that is a situation that is going to unfold and develop and remains to be seen. In other words, if the publicans are allowed to open in a month's time or 2 months' time or 3 months' time, will they be allowed to claim again for losses arising from the pandemic? And basically the High Court says they're going to look at very, very closely. It doesn't necessarily follow, and they will have to show that the cause of the losses is as a consequence of the pandemic. The fifth lesson to be learned from this case is that each of these cases, each of these policies will stand or fall on its own particular policies, on its own particular insurance policies, terms and conditions, and there would be some difference between the different policies, the different terms and conditions from the various insurance companies. And therefore it doesn't necessarily follow, even though there will be more cases probably, it doesn't necessarily follow that all publicans' cases against all insurance companies will succeed. It will depend on the particular wording of the insurance policy in question. Hope you find this video useful. If you do, I'd appreciate if you give it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, hit the subscribe button and hit the bell icon and you'll be notified every time I publish a new video. Thanks a lot.